Hi, I'm New Mexico attorney Nadia Cabrera Mazio, and today we're talking about how to protect your personal assets as a farmer or rancher. According to the USDA, almost 90% of farm and ranch businesses are sole proprietorships. A sole proprietorship is the automatic default type of business entity. You don't have to register as a sole proprietor or anything like that in New Mexico. You just start doing business. In a sole proprietorship, there is no legal difference between the business owner and the business itself, which is why we talk about liability protection, and LLCs and corporations provide that. In a sole proprietorship, the operator does business directly with the public, whereas with an LLC or corporation, it's not like that. It's the business, the company doing business directly with the public, and the owner of the business has a separate relationship with that company. That relationship is really important, and that's mostly what we're going to talk about in this video. When we talk about liability protection in this context, we are talking about protection from being held personally responsible for the debts of the business. This can look like many different things. For example, if the business takes out a business loan and then isn't able to pay it all back, then the owner is not going to be personally responsible for paying off that loan, unless they personally guarantee it, which is not encouraged, but sometimes is necessary. Another situation would be if the business gets sued by someone because something happened and they got hurt, and that judgment is very large, and whether or not you have insurance, the insurance might not cover the full amount of the judgment. So in that case, if you don't have a strong liability protection with your business, you are exposed to having to personally pay out of your pocket to satisfy that judgment. This is where we get the potential for losing your personal property. If you don't have enough cash in the bank to be personally responsible for these business debts, then the creditors are going to look to any possible avenue of getting paid back, whether you have personal assets or other things that they can go after. That's where LLCs and corporations come in. There are also a few types of partnerships that provide liability protection, but for our purposes, we're going to focus on LLCs and corporations. LLCs are not the same as corporations. LLC stands for Limited Liability Company, and it's similar to a corporation in that it's a way to create an entity that is its own kind of legal person. It's not really a person, but it's a legally independent entity. So the entity itself can own property, can take out loans, can have business credit, it can enter into contracts, and all of that is different than you doing that directly. The liability shield, or corporate veil as it's sometimes called, must be actively maintained through proper business practices. It is up to you as the business owner whether your liability shield is made out of steel or aluminum foil. There is a doctrine called piercing the corporate veil. A creditor might ask a court, a judge, to go through your liability shield, completely disregard that protection that your business provides, so that the creditor can dip into your personal pocket regardless of whether you have this fancy LLC or corporation set up. That's why maintaining a strong liability shield is so important. You want to make sure that a judge or any third party can look at the papers, can look at the paper trail, documentation, and clearly see where you as the owner ends and where the business begins. This is easier said than done, especially for small family-owned businesses. There's often no practical difference between you personally and your business, but on paper, you have to show that you're treating it like a true independent business. You're not treating it like an extension of yourself. So you want to make sure that it's very clear to anyone looking from the outside in that you're following those proper business practices to keep the liability shield strong and to show that there is a difference between you as the owner in your personal capacity and you as the operator of this business. A good rule of thumb is to imagine that somebody else owned the business. What hoops would you have to jump through in order to do business and transact with that person or with that business. Make yourself jump through those same hoops in your own business. It can seem pretty silly, especially if it is just you or just you and your spouse or you and your 3 kids. It can be silly, but it can look like sitting down at the dinner table with your family, calling a meeting to order, having an official formal meeting to discuss big decisions that might affect the business, and then taking minutes, just taking some notes about the major things that were discussed during that meeting. And then, importantly, keeping track of those minutes, keeping track of all of those documents so that you can access them and show them to people if it ever does become a problem. The main things you have to do to keep a liability shield strong start with separation of finances and assets between you personally and your business. This can look like if you own the land that your business is farming or something like that, then create a paper record. Lease your own land to your business. And if depending on how you're moving money around between yourself and the business, this is a good way to also legally and properly move money around. You can have your business pay you to lease that land. This is a normal thing that most everyone does when they're using somebody else's land, and your business is using somebody else's land. It's using your land. Unless the business itself owns the land, then there has to be that little hoop that you jump through to show that you're not just treating the business willy-nilly like an extension of your personal self. Each factor that we talk about isn't going to be the be-all, end-all to determine whether a creditor can dip into your personal pocket, but some of them are weightier than others. Keeping finances separate is one of those. If you're commingling personal and business money, if you only have one bank account for both, if you're using, even in a separate bank account, if you're using those business funds for personal expenses, then that's a sure sign to the court or a creditor or whoever is looking into this that you are not following those business practices and that you're just having this kind of shell corporation to try to protect yourself instead of truly giving it the deference that it deserves as its own legal entity. Another heavy factor that is going to be worth a lot is how you're handling those business funds. Undercapitalization happens when the business does not have enough money to stand on its own 2 feet. It does not have enough money to continue operating. If that's true and that's a result of the market and just business is slow and you truly don't have enough money, you can bankroll it with your personal funds and that's not going to count against you. But if the business did have that money and you took it all out of the business and put it in your personal account so that it couldn't be used for business purchases, then that's a problem. Another factor is to document major business decisions. We already talked about that one. Of course, have bylaws and an operating agreement and actually do what they say. You should be able to know where those are and generally what they say. And when things change and your practices aren't reflecting the policies that you set out in these governing documents, you need to update those documents. Carrying proper insurance is also a major factor. Depending on your industry, whether it's very high risk or not, you might be able to get away with not having insurance. But for something like food sales, which is a very high risk industry, it would be madness not to have insurance. So if you don't have insurance in that case, it's also a sign that you're not following these proper business practices and that a creditor might be able to dip into your personal pocket to pay off business debts. Another factor that a lot of people tend to forget about is putting your title and the company name when you're signing documents. This can also be a little silly because sometimes you're signing something and there's just no room for more than just your signature, but you absolutely have to put the fact that you are not signing as your personal self, you're signing in your capacity as a representative of your organization. So your title and the name, the legal name of the business is incredibly important. Otherwise, it just makes things messier if there is a dispute. It doesn't necessarily mean that you will be personally responsible, but it absolutely opens that door and will require a bunch of legal arguments if things get messy. And finally, issuing corporate stock. So if you choose a corporation as your entity type versus an LLC, then you're going to have to follow even more formalities. Like, a lot of these things are really important for keeping that liability shield strong, but they're not written into the law. For corporations, however, a lot of these factors are written into the law. So not only are they important to maintain that liability protection, but for corporations, they are absolutely important to maintain the legality of the corporation to begin with. These are all of the hoops that you have to jump through to maintain that strong liability protection with your business, whether you choose an LLC or corporation. I created a self-assessment to gauge the legal health of your business. It's linked below, and you can go through all of those factors and see where you're at and see how you improve over time. Stay tuned for more from the Farm and Ranch Legal Series.